I have determined that 45 minutes should be sufficient in chief, and then half an hour in answer, and then 15 minutes in reply.
Thank you, my lady. That should be in order. Thank you.
Thank you. Is that in order with you, Mr. Matau?
Yes, my lady, that's more than generous.
Yes, I agree.
Thank you, my lady.
Yes. Yes, when you're ready, Mr. Mpofu.
Yes, my lady. Thank you very much, my lady. My lady, yes. Your ladyship would also have received, together with our heads, we also filed the case of Baloyi.
Yes, I haven't looked at that. You'll refer me to the part you're relying on.
Yes, I will, my lady. Your lady will find it on case line at 02-594. I'm just flagging that case because I'll be referring to it quite a lot.
Okay. Thank you.
Thank you, my lady. Right. Well, my lady, as you have correctly pointed out, and we always tell pupils and students that the two things you don't do in the application for leave to appeal is to try to tell the judge that he or she was wrong, because that's just a waste of time. But also not to re-argue the case, as it were.
Yes, thank you.
Yes.
The latter being more important than the former, because judges can be told that they're wrong. We've got broad shoulders and strong stomachs.
They should, my lady. But of course, they can be told. But the point I'm making, my lady, is that that's not the object of the exercise.
Indeed.
Yes, the object of the exercise is merely is a much simpler one. Try and convince the court that a higher court would come to a different conclusion.
Yes.
Which is much simpler than trying to prove that the court was right or wrong.
Yes.
So we start right there, my lady, and but by way of signposting, if you may, this judgment really rests on two important legs, and that is what we're going to address. The first one is that the matter does not involve constitutional rights, and therefore the court has no jurisdiction. That's the essence, really, of the judgment.
Well, I don't think that puts it, and I think we must at this stage of inception. I don't think that puts it accurately. The question is not whether the court has jurisdiction. The court clearly has jurisdiction, and that is why a judgment was given by me. The question is whether the section 1721 constitutional jurisdiction is invoked or may be invoked. Call it jurisdiction, call it power. That is the question. Whether the application is such that it allows for the invocation of section 172, which we know is a very important section in the Constitution.
Yes. Well, my lady, with respect, that's really it says the same thing.
No, it doesn't, because the court either has jurisdiction, which I did have, to entertain the matter. The question is whether you can rely, or your clients can rely on section 172, and I found that you couldn't.
Yes.
So maybe, that's the point. Maybe I don't want to be at cross purposes with you, Mr.
Well, maybe it's easier so that there are no cross purposes just to read paragraph 44, which is the conclusion. And says, it's exactly what I've just said. This is not a constitutional matter, and it is not one where the court has jurisdiction. That's all I'm saying. I'm not saying anything more or less than what that paragraph
the court doesn't have jurisdiction to go on to the inquiry that would be necessary under Section 172. So, and you can find that in, if I go to my judgment, it frames the, it frames your declaration of invalidity. Because what I like to do when I write a judgment is to say, well, this is the question that I need to decide. I think that is that's a good place to start in a judgment. So at 12, the question is framed. The main foundation on which the case of the applicants rests is the declaratory relief sought. Section 172A of the Constitution states that this court must declare any law or conduct that is inconsistent with the Constitution to be invalid to the extent of its inconsistency. Section 172 is a special constitutional provision, and its application is specifically related to the breach of constitutional rights. The inquiry is an objective one. Conduct is either inconsistent with the Constitution or it is not. And that's the inquiry that the court embarked upon. A court having, the court has jurisdiction to entertain the argument, and it embarked upon that inquiry. That is clear from the judgment. So as I understand it, having read that, as I understand it, the question is, would another court, would an appellate court find that there was a constitutional issue entailed, thus being worthy of to? That's the question.
All right. Okay. Right. Then let's, again, I think it's better to just go to the judgment. The paragraph 15, apart from saying there's no jurisdiction at the end, it says the starting point of the inquiry is whether the declaration involves constitutional rights.
That's the point of departure. That's our point of departure. That was my point of departure in the judgment.
Yes, that was the only point I was making, which was
yes,
that, yeah, whether the matter involves constitutional rights and therefore whether the court has jurisdiction, either in the sense that
under one step to make the declaration that you seek.
Yes.
Yes.
That's all really there.
Yes.
So as I was saying, the case then rests on those two legs.
Yes.
So if we can then start with the first one.
Yes.
Which is whether the matter does or does not involve constitutional rights.
Yes.
Right? Okay. And bearing in mind, again, that this is the exercises, as your leadership has just summarized it, whether another court would find differently.
Yes, would find that there's a constitutional
right implicated at all in the first place. Yeah.
Indeed. Indeed.
Yeah. Okay, so let's address that then. Yes. Now we say very clearly both in the application for leave to appeal and in the heads that the fact that the case involves constitutional rights is self-evident, is common cause actually, and in that say so. They might differ about all sorts of other things, but both parties agree that the matter implicates Section 16 of the Constitution.
Look, I don't know if there was such an agreement, because I understood the approach to be different. But okay. even if you are ad idem in relation to that, the fact that constitutional rights are implicated, I'm not bound by that.
Yes. Well, then that's a different matter. The courts, yes, that's the approach that was taken by the court, but that is
And
not,
neither would an appellate court be bound by that, clearly.
well, except if that court was the constitutional court, it would be bound, because that's what the constitutional court has said.
No, well, you're not going to the Constitutional Court. You're not asking to go to the Constitutional Court. And it would be nice if we could leapfrog over everything and land in the Concourt, but we can't. So but you've asked specifically for the SCA, as I understand.
Yes, but actually we can, by the way, go to the Constitutional Court, but that's...
But you haven't asked for that, Mr. Mpofu.
No, I can't ask for that.
Well, indeed, that's the point I'm making. You
No,
can't ask for it.
I can, but I cannot ask it from you. I can only ask for it from the Constitutional Court. It's
Oh,
called an
okay.
application for
No,
the-
but you're before me now, so I can only give you what I can give you. I can't give you more. So from me, before me, you can only ask for that. Yes, so we understand each other.
All right. Anyway, the Constitutional Court, which is binding on you, has said that...
Of course.
Yes, has said that the test for, in Gaba, the well-known case of Gaba, the test for whether or not the matter falls within the jurisdiction of the court, even in the sense that your ladyship has qualified now, is based on the pleadings, right? That's right. So the pleadings, unfortunately, come from the parties. So if the parties have pleaded a case in a particular way or another, that's what the court is bound by in a way.
Well, I'm bound by statute. I'm bound by the Constitution. So whether the parties tell me I have a jurisdictional point to consider or whether they don't, I'm bound by the Constitution. And it says that I only have the power of declaration under 172 if I have a constitutional issue at stake.
Yes.
And if I find that I don't have one, regardless of what any of the parties have said, I can't say, oh, well, because you tell me that there's a constitutional issue, I must now decide the matter on the basis that there's a constitutional issue. That's not the legal framework.
Okay. Well, then it's that's a different law, because in Baloyi, which is what I said I would refer to.
Me to go there.
Yes, please, my lady.
Just give me the case, the page.
Okay, it's 02-594.
Thank you.
And I'm referring your ladyship to the well-known framing of this very question, which was approved. Your ladyship, just to take you one step back, your ladyship will know that there's a whole host of cases, Chirwa, Fredericks, Gaba, and all that.
Yes.
We deal with this question. And then
yes.
Yes. The latest case in the Constitutional Court is a matter of Baloyi versus Public Protector.
Yes.
2022-3 SA 321.
I have it.
Yes. Now, in that matter, your ladyship would see that, in fact, it answers some of even the issues that we've just spoken about, because it was a direct appeal. Your ladyship, you would have seen, I argued this matter. I had in the High Court before a single judge, I was successful on this issue of jurisdiction. Yes. And that went directly, by the way, to the Constitutional Court. And the Constitutional Court found that success, as it were, was short-lived because of what I'm about to say now.
Yes.
The courts have said, and the court said it gave leave to appeal to itself, by the way, for the reason that this was a question that had not been answered in all those previous plethora of cases, which is true.
This is about Labour Court jurisdiction, if I recall.
No, it's not. It's about the mere issue of jurisdiction. You remember in Chirwa, it was Labour Court. It was whether you could go to the Labour Court or not. And in Gaba, it was the same thing, and various other cases. In this case, it was more closer to what we are busy with here, as to whether when the applicant has asserted a constitutional right, then the court can say, no, we don't have jurisdiction, to entertain the constitutional issue.
Yes, I have the point. It's a question of exclusive jurisdiction. The law said the Labour Court had, or the statute said the Labour Court had exclusive jurisdiction. As I understand the case, it held that where a constitutional issue is at stake, that doesn't apply, and the court has jurisdiction.
No.
Am I correct? No. Well, then you must correct me.
Okay. Anyway, let me rather just go straight. Maybe it will be easier to explain it once I've read the extract.
Okay.
So at paragraph 40 of Baloyi, the following passage from Makanya, Nugent J.A.'s real, very clear exposition of this area of law was endorsed by the Constitutional Court as follows. This is what Nugent J.A. said in Makanya. I think it's paragraph 73.
All right, and you're reading from, I've been taken somewhere by your junior, which is helpful, but where are you reading from? Is it paragraph 35? 40. 40.
Yes.
Yes, thank you. I'm there.
Yes. Okay, and I'm going to read. I'll jump all the. I'll read from against the letter B. When a claimant, don't know if your leadership is there. It's in the quotation of Makanya.
At 40.
Yes.
At paragraph 40.
Yes, there's a quotation of the.
When a claimant, yes.
Yes. Okay.
Yes.
Now I'm going to read that very clearly.
Thank you.
A claimant, meaning one of the parties. Yeah. When a claimant, the applicant in this case, Mr. Zuma and MK, says that the claim arises from the infringement of the common law right to enforce a contract, then that is the claim. And the court must, in other words, the court is bound to deal with it accordingly. Pause. When a claimant says that the claim to enforce a right as created by the LRA, then that is the claim, and the court has before it as a fact. And here's the important part. When he or she says that the claim is to enforce a right derived from the Constitution, then as a fact, that is the claim. That the claim might be bad, a bad claim is beside the point. Now, what does that mean in practice?
Well, what it means, can I just tell you how I understand it? It means that you said that there's a constitutional issue. I don't have to accept that there's a constitutional issue. And I found that your claim was bad, your client's claim was bad. But this is a question of whether it's the LRA jurisdiction or whether it's the common law, contractual jurisdiction. And in this case, the route chosen was the common law. And on that basis, it was a constitutional point. That's as I understand it.
No.
Okay. You'll tell me how you understand it.
Okay. No, it's not how I understand it. Let's start again. let's start with, then forget everything I've said. Just start with the third when. Okay.
The third when.
Yeah. When he or she, that means the claimant.
Yes.
Says, in other words, pleads, that the claim is to enforce a right derived from the Constitution, nothing to do with the LRA or the common law or anything. Says that the right is derived from the Constitution. Then, as a fact, that is the claim.
That's the claim, and that's your claim in this matter.
Yeah.
I accept. You say that it's under Section 16 and all that encompasses. And on that basis, it is a common law. It's a constitutional point that you're raising, and I must treat it as such. And that is what I did, and found that your claim was bad in law.
Yes, you did.
Yes. Yes.
Thank you. And that's wrong. That's exactly. Thank you, my lady. That's what the case says you are not allowed to do. So you are not allowed to, whether the claim is bad, as you say, is beside the point. That's what the cases say.
No, that's the point that I had to decide, whether it was bad or not.
Yes,
that's the point that I came to decide. Look, Mr. Mpofu, all this case says, it's not on point at all. All this case says, this case was a matter where what was raised by the claimant against the claimant was that the LRA creates certain rights, being the right not to be unfairly dismissed, etc. And the LRA, for that, in that cause of action, is the sole arbiter. It has the jurisdiction. The court said no. There are two ways of the case. The first is on the basis of the Labour Relations Act, and that's not what they did. They pleaded it on the basis of contract, and on that basis, the Labour Relations the Act section did not apply, and the general jurisdiction applied. That is all that this case says. So I'm afraid as we started off, the point that I had to consider was whether a constitutional right was invoked. I found that there was no such right. I never found that I didn't have jurisdiction. I found that I didn't have jurisdiction to declare under 172, or power, if you want to call it that.
Okay, my lady, I'm sorry, if your ladyship can just allow me maybe to develop the point. Yeah.
Of course. Yeah,
because I've not, your ladyship, no, that's not what the case was about. I just explained I was in this case, my lady.
Yes.
This was not the point. If that was what your ladyship is saying, leave to appeal would not have been granted by the Constitutional Court, because that happens every day, what you've just described. The reason why direct leave, not just leave to appeal, the Constitutional Court doesn't normally give direct leave to appeal to it. It says you must go to the SCA. The reason bleeds a constitutional right. Okay, let's forget about the LRA. That's what all those other cases are saying, or the common law, or the contract, or whatnot. Yeah. Yes. Simple. When a person pleads the violation of a constitutional right, as we've done in this case, and the court will find that the claim is bad or good. Okay. Because that is irrelevant. That's besides the point. That's exactly why leave to appeal ought to be granted in this matter.
Yes. Because
the court, as the court just explained now, took into account what this court in the Constitutional Court said is irrelevant, which is the goodness or badness of the claim. Okay, so that's the first point. Now, the reason why the Constitutional Court then granted leave to appeal is also linked to a second point. You'll see it's a short judgment. It says that we're giving you leave to appeal just on this issue of whether there's a constitutional right properly asserted or not. But on the merits, we are referring the matter back to the High Court or Labour Court or wherever you want to go. And the reason for the one of the problems with the current judgment is exactly that in finding that it doesn't have jurisdiction at paragraph 44, this court then effectively did not deal with the merits of the case as such.
The whole judgment is dealing with the merits of the constitutional point raised. You see, Mr. Mpofu, if you want to invoke 172 and you want to say to a court, you have the power with jurisdiction to make a declaration under 172, you have to show me what your right is. The right that you chose was Section 16, the freedom of expression and all that entails. I found that that was not invoked. So I don't have jurisdiction to decide the point. I decided the point on the basis that the jurisdiction under 172 is not, I'm not able to invoke it because I'm not dealing with the constitutional point. Yes. So that's the, you know, if I had not, if I was saying I don't have jurisdiction proper, well, I wouldn't have considered the case at all.
No, my lady, I'm so sorry. Maybe okay. I'm going to do this for the last time. The judgment says, my lady, at paragraph 44. Just go. Okay, not just a paragraph. Let's start at the issue of
the what? Sorry.
No, I'm just trying to. You say, my lady, at paragraph 44, which is your conclusion, right?
No, well, you can't just read one paragraph in the judgment. And I used jurisdiction in the conclusion on the basis of the jurisdiction accorded under 172. And my whole judgment says, Mr. Mpofu, the entire judgment starts from the premise that you've got to have in order for 172 jurisdiction to be invoked, you have to have a constitutional point.
Yes.
I then went on to consider whether you had a constitutional. I found that your client did not have a constitutional court point, and I thus found that there was no power to make the declaration that you sought under 172. So when I say the conclusion is I have no jurisdiction, what I'm saying is, and it's clear from the judgment, that I have no jurisdiction to grant you your declaration because you're not entitled to it. So it's more, you know, it's more nuanced than just reading the last paragraph of a judgment, because there are two concepts of jurisdiction here. There's the jurisdiction to declare under 172, and there's the jurisdiction of this court to determine whether there is such a constitutional point raised. So don't elide the two. I think the judgment is quite succinct and clear in relation to the jurisdictional point raised. When we started out, I made it clear that what I see as the central theme is whether your central complaint is whether there's a constitutional point or not. And you agreed. That's the point.
Yes, but that's what I'm addressing, my lady.
Okay.
With respect, if I'm allowed to speak, really, I will then address the issue. I'm saying, my lady.
Thank you.
I'm saying simply, where you have a party, after, I'm not going to go back to what Nugent and Teron J said, where you have a party saying that I am asserting a constitutional right. More so in this case, where the other side also says that this matter is in relation to the same constitutional right, but obviously from our point of view. Okay, so the SABC says to you, my lady, it says not. So forget about what the claimant says now, which is what the case law says. But the SABC says at paragraph 4, that the order the applicant seeks would violate the SABC's right to freedom of expression enshrined in section 16 of the Constitution. Okay, so we say it violates. I'm not sure it looks. Oh, okay. I thought it was frozen. So we say that it violates section 6, our section 16 rights, right? And the SABC says it violates their section 16 rights. That's what I'm saying. So in other words, one thing, the parties might disagree on many things, but one thing they are agreed on is that this matter involves section 16 rights. That's the point I was making.
But I have to be persuaded. Doesn't matter what the parties agree in relation to in relation to the power under my power under section 172, which is a very special power. It's a very special, a power which is not, you can't just leap in and say, well, this is, any issue is a constitutional issue.
We'll come to section 172. I'll explain what 172 says. Yeah. All I'm saying, my lady, and I'm moving from this point now.
Thank you.
Yeah, it is that if I don't have to convince you that you are right or wrong. We know what your judgment says. All I'm saying is that another court faced with pleadings where both parties say that the matter is about section 16 of the Constitution would think it is about the section 16 of the Constitution. That's all. I'm not saying you are right or wrong.
Yes, I have a point. I understand the point.
Yeah, the point is that where the parties, if one party says this is about the car and the other one says it's also about this car, then surely there's a reasonable that a court, a neutral person or any neutral third person will say this is about the car. Whether the car belongs to A or B is besides the point, as the cases say. Yeah. Yes. But what you cannot say is that it is not about what the parties say it is about. Yeah. So that's the one thing. Yeah. The ladyship is right that you still have to decide the point and so on, but you can't differ with what the parties say the case is about. If they say it's an RAF case, it's an RAF case. Whether it was the fault of this one or that one is a different matter. Okay, so now let's go to section 172. of the Oratile leadership. Section 172 is not, if at least we accept that we are dealing with constitutional rights, and that even the SABC in its letter of demand, I mean, it's the response to the letter of demand, my lady, which we quote at paragraph 16 of our heads.
Yes.
So they say, contrary to your client's allegation, Section 16 guarantees the SABC's right to freedom of expression and the exercise of its discretion, and so on and so on. And then in another paragraph, it says, your client's conduct further undermines the SABC's media freedom. So we put that aside. Now, faced with that, Section 172 is not necessarily a special clause. All Section 172 does is actually to allow citizens and everyone else the avenue through which to assert their rights.
Their constitutional right.
Yes, yes. Remember, we're done with that now. We're saying all the parties are saying it's a Section 16
well,
right. So that's
it's a question of whether I agree with you that I have to accept.
No, my lady.
And look, we'll have to agree to disagree on that, I'm afraid, because I'm not persuaded that I have to accept what parties say. I don't have to. If both parties call it a pot, I don't have to accept that it's a pot. I can say it's a kettle, because that's my power under 172.
All right. Okay, maybe let's go back to basics. Okay. Where there is a citizen of South Africa complaining that an organ of state or the state itself has violated its rights, whatever rights, you can choose each other one, dignity.
Yes, indeed.
Yes. Where that is the case, my lady, that is a constitutional matter. Okay, whether that it will be found to be so or not is irrelevant. Yeah. In other words, if I say Eskom has switched off my lights, in doing so, my right to life or whatever, let's say I was a sick person, yeah, my right to health, whatever, that is the claim. You can't, nobody, not even a court of law, can say no, that's not your claim. Because that's the claim. I might lose the case. That's a different issue. Yeah, but no one can say you are not asserting your right to health. One. Number two, no one can say, because Eskom is merely an extension of the state, right? That's why it's called state organ. It's an organ of the state. So its conduct is by definition that the conduct of the state against which, that's why we have a constitution in the first place, is so that when the state does anything, I as a citizen, Joe or Joe citizen, should then say, so there's no court in South Africa or anywhere in the world that can say, no, this is not a constitutional matter. It's not possible. It's humanly impossible.
Well, that's not so, because let's look at the right. We have to start, Mr. Mpofu, with the right that you rely on. Now, as I analysed the right, it was clear that there was it didn't touch on Section 16 at all, because what the right boiled down to that you were relying on is the right to receive information that was not controversial. And that is not a rule, a right which Section 16 espouses. On the contrary, it espouses the freedom of expression. So the right you said you wanted to rely on is the opposite of a constitution. It's not a constitutional right, and on that, and neither can any court declare it to be such.
Yeah, man. But lady, the Constitution of South Africa says everyone, right? That includes these claimants, okay, has the right to freedom of expression, which includes freedom to receive or impart information or ideas. That's in the Constitution of South Africa. Okay, so all one has to.
It doesn't say accurate or non-controversial ideas. It says everyone can express their ideas and people have the right to hear them. You've attempted to suggest that because the use of the term, as you call it, or the name, has some kind of controversy, it may not be said. And that is not a right you can invoke, and it's not a constitutional right. So that is the simple finding in the judgment.
Okay, my lady, I'm begging you to just stay away from the facts of this case or anything of the sort. I'm doing a legal principle here. I'm saying the right in the Constitution at Section 16(1)(b). Got nothing to do with anybody, or this case or any other case. The right is the freedom to receive or impart information or ideas. And all I'm saying, my lady, is that that right incorporates within it, in the context of the SABC and the what you call it, statutory framework and the policy framework of the SABC. That right necessarily involves the right to receive accurate, impartial, and independent information. That's all.
But you see, that's where you and I part, because obviously one reads Section 16 and it says that everyone's got the right to express ideas and to receive information. You are attempting to tack on a right that says you're entitled only to hear or impart controversial information, and that would be nothing short of bizarre.
Well, my lady, then Section 3(5) of the Broadcasting Act is bizarre.
Yes.
And you'll find that quoted at paragraph 33 of our heads.
Yes.
And it says, the SABC is constitutionally enjoined to ensure that members of the public have access to accurate, neutral, and pluralistic information. That's what the Parliament says. Then Parliament is bizarre, because it's Parliament, it's not me who says that the SABC must give accurate, neutral, and pluralistic information. If it's bizarre, then it's the Parliament that's bizarre. Right?
Well, we disagree, because a court can't say to somebody, you can't use a name because it's controversial. No. That would be bizarre.
But nobody has spoken about controversy, my lady. I'm talking about accurate, the word that is that is the Parliament has chosen. I'm not using other words that I'm going to make up, like controversial. The Parliament of South Africa has decided that the members of the public must have access to accurate information.
Yes,
if that's bizarre, it's bizarre.
And then there's a process under that act, and I think my judgment goes into that. With the process, it says, to the extent that there's any complaint against any accurate or inaccurate information, it's got to go under the Broadcast Complaints Committee, and it's empowered to determine accuracy. Yeah, this court is not. This court does not have to determine whether the controversial use of a term is accurate or not.
The ladyship keeps on going back to this thing of controversial. Okay. It's not my case. I'm not interested whether it's controversial or not, my lady. I'm saying that the law, the only thing we are debating now is whether the right to freedom of expression in Section 16, in the context of the SABC, entitles the public to have access to accurate information or not. That's all.
Yes.
Yeah. And according to Section 3.5 of the Broadcasting Act, it does.
Yes.
And if it does, then this case involves the right in Section 16(1)(b) of the Constitution. That's really the only simple point I'm making.
Yes, now I have the argument. I have the argument.
Yes, yeah. So all I'm saying is that, my lady, in the case of, I think it was your brother Klassen who made this distinction.
Yes.
That in the case of a private body, then that private body has got they can do whatever they like, basically. But in the case of a public service broadcaster, which is an organ of state, then
Yes.
its obligations are set out. So that's the
Yes.
first.
Yes. Now I have that argument.
Yes, yeah. So I'm prepared to go as far as to say there is no court in this country that can find that the assertion of the right to accurate information, as explained in Section 3 of the Broadcasting Act, is not actually a part of the freedom of expression qua in relation to the SABC. I'm prepared to put that money on that. So it's not a question of a reasonable prospect. There is no court in this country that can find that that does not involve the right that is asserted. So that's the first thing. Now, Section 172, my lady,
yes,
our courts have said it has the wide, not this restrictive meaning. It has got a wide application, and your ladyship will find that in the under where we deal with the declaratory relief in our heads, and that is sorry, my lady, I'm just yes, so from paragraph 27.
Yes.
Your ladyship said that your conclusion was that you are not, as you are saying, you are not bound by what the parties are saying.
Yes.
And the ladyship based that on a case called Ferreira versus Levine.
Yes.
1996 2 SA 621. And the ladyship relied on paragraph 57 of that judgment.
Yes.
Well, the only problem is that that judgment doesn't have a paragraph 57.
Yes, it's a typographical.
Okay,
error.
well,
I think it was paragraph 7.
7, no. Well, but I've also thought about that. There's nothing of the sort in paragraph 7 either.
All right, let's go to Ferreira and Levine, shall we? You want to go there? Do you have? Is it on case lines?
No, it's not. But I can 2002.
Okay, let me
6. Yeah.
Let me see.
But if your ladyship will allow me to stand up.
Yes, stand up, please.
I've got it. Yes, it's here. 2002 642.
Yes, let me go there. I'm just bringing up my my Juta stats.
Yes.
So will you bear with me?
Yeah. I'm sorry, my lady. I'm the one who's misleading you. 1996 2.
So it's Ferreira versus Levine.
And it's 2.621.
Just hold on. Let me go to Jutastat. We have to bring up a whole new VPN in order to do that, but it generally is quite efficient. So let me just go there. And just give me the year.
1996 bracket 2, my lady.
1996. 2, page
621.
621.
It's a constitutional court decision.
Let me just close it. Oh, it's the wrong case. This is the costs case.
Okay. Anyway,
it's the main case, not the costs case.
Okay.
So obviously, my clerk, when she was referencing, she came up with the wrong case.
okay,
But I'll give you the right. The right case appears in the judgment. So it's Ferreira Levine 1, not Ferreira Levine 2, and that does have many paragraphs. So if you'll go to that paragraph, it's a typographical error on the citation.
Okay, what is the correct citation then, my lady?
All right, let me get it.
Footnote 43, my lady, if I might just assist to save time. Footnote
Thank you, if you would.
Footnote 43 of the Baloyi judgment that our learned friend is relying on.
Yes.
Of Baloyi, 43.
But footnote 43, you'll see in Baloyi, the Concord refers to paragraph 155 of Ferreira versus Levine.
150. Okay, can you find
There
it?
it is, yes.
All right. Okay.
So
there are
that
two
is
judgments.
the case. There are two judgments.
Yeah, no,
One
we
is
all know.
costs,
Yeah, yes. No,
and the other is the main judgment. And often with constitutional cases, there are lots of related cases, and costs are determined separately. So one doesn't want to, one doesn't. I'm sorry that you were confused, but I think it's clear.
The judgment says this. Yeah.
I know. I'm sorry that you were confused by it, but clearly, I think clearly it's clear what judgment is entailed. And your Mr. Mattar's pointed out the correction. So I'll see to it that the judgment is corrected and revised with the correct citation. Right. Doesn't change the fact that Ferreira and Levine at 57 in the main judgment is properly relied on. So I'll make the amendment, but that doesn't give you the right to go and appeal, I'm afraid. A miscitation.
Well, my lady, if you just allow me to speak, please, my lady, I'm begging you.
Yes.
Yes. All this is really not necessary because we say in paragraph 27, I say, even assuming this was a typographical error, so it's just a waste of time now because we've postulated this, if your ladyship allows. So the case nowhere deals with the issue. The correct principle of our law is that the applicant's pleadings define the cause of action. I've already made that point.
Yes, no, you've made that point.
This is therefore a gross misdirection of both fact and law. And then I say at next paragraph, which is really coming to the point I was trying to make painfully. Yeah. Not only does the court have the power to decide the dispute, but the power to grant a just and equitable order, which is really what we're after, is so wide and flexible that it allows a court to formulate an order that does not follow prayers in the notice of motion or some other pleadings. And it says the power enables the court to address the real dispute between the parties by requiring them to take steps aimed at making their conduct to be consistent with the Constitution. That is all that we wanted from this. And that second paragraph comes from, again, a binding decision on you, my lady, which is the EFF versus Speaker of the National Assembly, the well-known Gandla case.
Yes, I've got that case.
So that case says the exact opposite of what you're, whether the citation is wrong or there's a typo or whatever, that's irrelevant. Yeah. The point is that the law is that the powers under Section 172 are so wide that a court can even go beyond what the parties have defined.
You are correct, but there's a proviso. No. Provided there's a constitutional issue. Provided there's a constitutional issue.
No, okay,
and that's the first question that any court has to decide in this kind of debate. So yes, the powers are very wide. That's why it's special. But only when there's a constitutional issue.
Yes, but we've gone past that, my lady.
We have, yes.
Yeah, please. I'm assuming now that we've gone past whether Section 16. Otherwise, you're taking me back there. I've ad nauseum explained how Section 16 applies. So that you must take for granted now. That
yes, I think we'll have to differ, but I understand the argument.
No, but we can't differ on whether I've submitted that section.
No, you've made the submission.
Yes.
But we differ on the submissions, whether I agree with them or whether I don't. So you can move on. All you have to content yourself with is that I understand the argument that you're making, but I differ with you. So move on to your next point. Is there anything new, Mr. Mpofu? Because even leeway over time.
Well, my lady, I have not said anything. Your ladyship, if your ladyship can just allow me to develop my arguments, please.
I will.
Yes. Okay. Then to answer this point that you're making now, my lady, this is what Musaneke said in the case of Department of Education and Hoër School, Ermelo.
Ermelo, yes.
Yeah, you'll find that in paragraph 30. It says the remedial power envisaged in section 172(1)b is not only available when a court makes an order of constitutional invalidity of a law or conduct under 172(1)a. It can be clearer than that. Right?
Yes, what that means is that what the dispute was, I'm very au fait with that case, and I want to tell you what I understand it to mean. And unless, if you want to just talk at me without me giving you an indication of what I'm thinking, so that we can come to a proper resolution, then do that, Mr. Mpofu. But I'm telling you what Ermelo means. Ermelo doesn't say there doesn't have to be a constitutional issue. It says there doesn't have to be a declaration issue. That's my understanding of Ermelo. So now you can answer. Now you know what is in my head, and you can tell me what you say about that.
All right. I'll just read the rest of the case for what it's worth here. A just and equitable order may be made even in instances where the outcome of a constitutional dispute does not hinge on constitutional invalidity of legislation or conduct.
Yes.
The ample and flexible remedial jurisdiction in constitutional disputes permits a court to forge an order that would place substance above mere form by identifying the actual underlying dispute. And we've agreed, at least not agreed, but we have established in this matter that the underlying dispute is one that deals with section 16(1)b. Okay. Now, I
remember you saying, Mr. Mpofu, when you argued in front of me in the matter, that this view that you were putting forward in relation to Section 16 was very novel, because it constituted it spun on its head the right to hear rather than the right to express.
Yeah.
And I'm afraid that I can't see the novelty in your argument. I don't find the novelty.
Yes, that's clear from your judgment. The
Yes.
only issue is whether another court would find the novelty or not, right? Not whether you, I'm not here, if I said when I open my mouth here, if I want to convince you that you are right or wrong, we can be here all night and day. Yes. I'm not about to do that because human nature doesn't allow for that. Yeah. So all I need to convince you today is not that you are wrong, because that would be an impossible task. You were right, let's say. The only issue is there a possibility, objectively speaking, that another court might find that, for example, what Klassen J said in the SOS case, you remember the SOS case versus SABC. He said, Section 16 of the Constitution enshrines the right of the public, the SABC's audience, to be able to access information and ideas so that they can enjoy their rights. That's all. If you think he was bizarre, as you said, well, then he was. But the point is that you are bound by what this court, this very same court, has said the rights are. And this court has said that those rights are the rights of the audience, literally taking the words from Section 16b, to be able to access information and ideas. That's literally verbatim from Section 1b, so that they can enjoy their rights. Now, you might differ with that, but that's what the law is in this division, at least. Yeah. Yes. And that's really the only point I'm making. So therefore, if number one. Number two is that your sister Yakub, your brother Klassen, said this was the case. Your sister Yakub also found that the matter implicated Section 16. Now, if two judges in the same division have a different view to yours, that the matter does not, then no, it's not that you are right or wrong, or they are right or
I understand. Yeah. I understand what the debate, and I understand my role here. You can rest assured.
Okay. Yeah. So all I'm saying, my lady, and really this thing should end here, is that this court, in two different matters, has found that it implicates constitutional rights in terms of Section 16, and therefore, surely there is a reasonable possibility that a higher court would agree with those two courts and disagree with your leadership. That's all.
I have the point.
Yes. So on that basis alone, my lady, your leadership is duty-bound to grant leave to appeal. Because otherwise, it would mean your leadership is now behaving as a court of appeal, as it were, but which you can't, because these are courts of equal standing.
No, I understand the principle of stare decisis. You can rest assured.
Okay. Now, here's then is the thing, my lady. The reason, for example, why Justice Yakub said that we should comply with Rule 16A and refer the matter to the Deputy Judge President for a special allocation was exactly because the matter involves 16A would not apply if it didn't involve a constitutional, constitutional rights. Yeah. So again, all I'm saying is that the least your leadership can do is to say, well, this is my view, and obviously your leadership holds the view strongly, but just have what is called in one of those cases the humility to say that, well, that might be my view, but the other people have held it differently. And
well, that's what every appeal court has to do.
Yes. No. But every appeal court doesn't delivered with this manna from heaven, where there are two views by the very same court going left another one going right. That is the classical requirement for leave to appeal. That's really the only point that we're making. Now, we say, my lady, I just want to go to a very fundamental issue.
Yes.
Let's assume your ladyship was right in relation to the declaration order. Okay. Now, where is the jurisdiction point in relation to the review? Because again, at the risk of explaining the obvious, if you have claim 1, and let's assume there's no jurisdiction in terms of claim 1, but I also have alternative claim 2, and I have jurisdiction in terms of claim 2, then the court cannot say that there's no jurisdiction.
Yes.
So the review order, my lady, is
the jurisdiction comment only applied clearly in terms of the judgment, if you read it, to the jurisdiction, that's section 172, that special jurisdiction. And I can't put it any plainer than that. I dealt with both points that were raised. So can we just move on? I decidedly did not suggest that I did not have jurisdiction to entertain the Pudger review that you wrote. I dealt with it succinctly, but I dealt with it.
Yes, my lady. You're saying we must move on, but that's exactly what I'm doing. I'm moving to the review now.
Oh, good.
You don't mind?
Okay.
Yeah.
Yes.
Okay. So I'm saying, my lady, that as that claim is concerned, your ladyship based it. I've explained what I said. You based your first claim on. Now, this claim, which is a standalone claim, firstly, at least we must all agree that it is within the jurisdiction of the court. Because
100%.
Yes, good. Now, if we do, then my lady, your ladyship then had 2 grounds for finding
For the Pudger.
Yes, for the Pudger. Yeah. And the one for legality will come to now, because that was also not with respect, not considered. Yeah. But let's start with Pudger. With Pudger, there are 2 things that you say. Say one is the non-exhaustion of internal remedies, the point that you were raising, yes. Unfortunately, in relation to the declarator. It really belongs to this part. Yeah.
To that part, I agree.
Yeah, no, not the first part. Yeah.
Yes.
And the second one, you said because the CEO doesn't have the power. Those were the only 2 grounds.
Well, that's a process question, see.
Well, but
yes,
that it's in the judgment. I don't know what it is, but those were the two grounds that you raised. One, non-exhaustion of internal remedies. Second one, the CEO point. Yeah, yes. Both of those are objectively wrong, my lady, and misdirections. Let's start with the exhaustion of internal remedies.
Yes.
My lady, we have in the case of Islamic Unity, which I cited to your ladyship even at first.
Yes.
Distinction is made between a complaint, which this is not, and I think it's and a matter that raises that relies on the constitutional point of Section 16. So a complaint about a particular broadcast, yes, you have to go through all those internal remedies. But when you are complaining about the violation of your rights, you come to court. So that's there's a reasonable possibility that another court would Islamic Unity is binding and therefore the matter to be entertained on that basis. But besides, my lady, your ladyship overlooked completely the fact that the applicant had asked the court in terms of Section 7(2)(c) of PAJA to be exempted from the internal remedies. Now, your leadership could have said, no, I'm not going to exempt you, or I'm going to exempt you. But what you cannot do is just to ignore that Section 7(2)(c) thing, which you'll find at paragraphs 81 and 82 of the founding affidavit.
Yes.
Where it lists the grounds upon which the applicants ought to be exempted from the internal remedies. The leadership did not deal with that matter at all, one way or the other. Neither say you are exempted or you are not exempted. You can't do that. If the case is going to be debated, to be determined on this aspect of internal remedies. So that's the one glaring misdirection.
Yes.
The second one, my lady, is this CEO point, which quite frankly, I don't know where it comes from. It says that the review is directed at the refusal of the CEO to have the SABC stop and so on. So this does not involve the CEO. The CEO is not empowered to take steps demanded by the applicants. It's actually painfully wrong. What was being done, my lady, was not to ask the CEO to do anything. What is being asked is to ask the SABC. The CEO just happens to be the person that you write to, as we say, like you write to the DG if you're writing to a department. But this was about the SABC itself, right? So your ladyship's, the entire debate about the CEO has power or no power is inexplicable at best, yeah, because the pleadings are very clear. You'll go to paragraph 13 of the founding affidavit. It says the respondents in plural, but paragraph 74 is very clear. It says the SABC. And again, if you go to the Yakub J judgment, it's very clear that it's the SABC that is being impugned, rightly or wrongly. So both the grounds upon which the review application has been dismissed are clearly, objectively wrong, and as a result of misdirections. So what I'm saying, my lady, is that even if your ladyship was somehow right that this does not involve a Section 16 right, we know that PAJA in Batista or Reagan said a matter of a review is by definition constitutional. So again, it brings that whole point. So we now have two constitutional bases, Section 16 and Section 33 of the Constitution.
Can I take you to a notice of motion?
Yes, notice of motion.
In your application.
Yes, which we must read with the founding affidavit. Yes, you can.
The relief that you seek is the review and setting aside of the decision which was communicated by means of the SABC letter dated 28 June 2024. So that you specifically deal with that letter, and that is what you seek to have set aside in your notice of motion. And you know, a court, Mr. Mpofu, as you well know, a court has to be confined to what you plead, and you plead that letter.
No, my lady, it doesn't work like that. Your ladyship knows that. You can't read a notice of motion and leave it there. There's ample law, your ladyship knows that the notice of motion must be read with the affidavit.
Where do I find the decision that you impugn then? Okay. Because you locate it in the CEO's letter and you specify it in your notice of motion. Oh. Where am I to find the impugned decision? Are you suggesting that your notice of motion is not correct when it suggests that that is where the decision lies? Because that's the basis upon which the judgment flowed.
My lady, are you seriously suggesting that if I apply for the a passport and some minor director writes me a letter and saying you're going to not going to get it, then I'm not impugning the decision of Home Affairs, but of that person who wrote the letter.
But can you take me in your founding affidavit then to the impugned decision? Because there's got to be one.
Yes, but okay. The first one is
I can't just say, well, you know, I must give a general order in relation to the impugned decision and find an impugned decision that you don't rely on. That's not how administrative law works, as you well know. I'm bound by the pleadings, as you yourself state.
A lady, okay, I don't know what your ladyship understands by the word communicated, right? If something is communicated by a person, it doesn't mean they made the decision themselves. I mean, that's not even law.
I have the point.
Yes.
I have the point.
So your ladyship can't just go to the notice of motion and say because it's communicated by a letter, then it means that's the decision of the CEO. I mean, where does that come from? If it's communicated by her, and you can actually go to the letter itself, my lady. You'll find it at 02-20.
So where do I have the decision that was taken? Because on that basis you haven't located it anywhere.
But I have.
You don't say who took it. You don't say what the process was under which it was taken. Look, somebody doesn't have. I'm getting a. Please all mute yourselves. I've given the right to record, but that doesn't mean that you can interfere in the running of my court.
Okay, my lady.
Sorry, Mr. Sorry, Mr.
No, it's okay, my lady. Yeah. Let me take your ladyship. Just walk your ladyship through the pleadings. Yeah. Okay, so we say it was communicated by that letter, and
yes, but who took the decision?
Yes. I'm getting there, my lady.
Okay.
If your ladyship allows me. So that's at least the first step. We're making progress. That this was merely communicated by the CEO, not made by her.
Mm-hmm.
Now, then we go to paragraph 13.
13. Just give me the page.
Just go to -146.
Thank you.
Is that correct?
Yes.
Yeah, you'll see.
Yes.
Then it says, we seek relief in the form of an order reviewing the respondents. The apostrophe is after the S, okay?
02-146 brings me to Kekana.
Okay, no, then that there's a mismatch. Let's go to the notice of wherever your ladyship found the notice of motion.
Yes.
It's you've just been directed, I'm told.
Thank you.
Paragraph
Thank you.
13, yes.
Yes.
Paragraph 13, yeah. Your ladyship will see that. Main relief being, we seek relief in the form of an order reviewing the respondents, and you see the apostrophe there is after respondents. In other words, the three. SABC.
That I've gone to doesn't have a 13. The page that I've been taken to by your junior is 02-610.
No,
I don't have a 13. I'm being directed not somewhere else. I'm going to go there. This is the founding affidavit, yes. Now I've been directed to the right. So you want me to go to 13? Yes. I have it.
Okay. It says, we seek relief in the form of an order reviewing the respondent's decision. Okay. That is the SABC. That's the first respondent. And so this is just shorthand. So the decision is that of the SABC, and then the other respondents that are cited are the the board and the CEO. So that's the first part that shows that is the 3. Then go to paragraph 74.
Yes, a page. Mr. Mpofu, I must please, I've given so much leeway, I must please ask you to start wrapping up. As I said, I've read the heads of argument, and I'm on top of your arguments. So please, can we just wrap up?
Well, my lady, with respect, if your leadership still thinks that the decision was that of the CEO, I can't say your leadership is on top of my arguments, because my argument is exactly that.
I know what your argument is.
It was not. It was not. I'm afraid, yeah. So at paragraph 74, it says in the alternative, and it's so far, yes. You asked me to direct you to where I identify the decision. Yeah.
Yes.
Paragraph 74. Are you there? Yes. In the alternative, insofar as the SABC, not the CEO, right, despite demand, took the decision. That's where you're asking me to direct you. That's where it says. Yeah. So that firstly, you can't read the notice of motion on its own. B, even if you could, it says it was communicated. But C, it says here who took the decision, which is the SABC. So this whole thing about the SABC, the CEO not having power and so on, is just completely addressing something that is not what the case is about. Yeah.
Yes, I have the argument.
Yes.
Can you move on to the next point?
Yes. Okay. So the point is the point is the following, my lady. To the extent I'm just going to wrap up the whole argument here. One is that the matter clearly and its common cause implicates section 16(1)(b) of the Constitution. 2 is that implication is reaffirmed by section 3(5) of the Broadcasting Act, which entitles a person in terms of section 16, not just to information per se, but accurate information.
Yes.
3 is that the section 172(1)(b) does not, the granting of the relief that we seek, which is that you'll find that in, sorry, my lady, paragraph 3 of the notice of motion.
Yes.
Says, the relief is 172(1). Now it says that relief does not depend on the declarator of invalidity per se, because it's a wide power. So clearly, in terms of the declarator, the leadership got it wrong. Just the approach. And
in terms of, it would be in terms of Hoërskool Ermelo.
Yeah, Hoërskool Ermelo, yes, my lady, I agree.
Yes.
The formulation in Hoërskool, yes. So there's a reasonable possibility that another, whether it's the SCA or the Constitutional Court, is irrelevant, because the SCA is bound by the Constitutional Court anyway.
No, indeed.
Yes. So the SCA or whichever court would then agree with another court would agree with Ermelo. Yeah. Okay. So that's as far as the declarator is concerned. As far as the review is concerned, my lady, the 2 grounds upon which your leadership dismissed the review, namely the non-exertion of internal remedies and the CEO point that we just debated now, are both not applicable, to put it nicely. Yeah. Because the first one is as I say, it ignores the section 7(2)(c) thing, and the third one is just a misreading of the pleadings, because there's no decision of the CEO that is impugned. Yeah. Now on that basis, my lady, for all those reasons, even for one of them, yeah. But the most important one is that even as far as the jurisdiction point or the power of the court to determine the matter is concerned, even if the only thing that we had brought before you was simply the Paja review, your leadership would still have the power. Would still have had the power, stroke jurisdiction, whatever you call it.
Of course, it's a judicial review.
Yes,
and I determined it, and you say I've determined it on 2 grounds, and now you're saying that let's not get mixed up with the nuance of jurisdiction. We started off on this Paja review on the basis that clearly the court had jurisdiction. The court entertained the matter. As you yourself argue, I found on 2 bases. You say I'm wrong on those 2 bases. Does that put your case succinctly? Because I'm going to stop you at this point. I have the argument. I've given you a long time. I've done so because I have attempted to give you a sense of what my thinking is in the matter, and that may have caused delay. But I'm giving you 5 more minutes.
Thank you, Madam. Actually, yeah, the only other point was the fact that, which links to the first one, by the way, about the assertion of rights. The leadership also then found, as far as costs are concerned, that the Mpofu-Walsh principle doesn't apply. But that's just a child of the first mistake, that Section 16 is not being asserted. I'm sure if your leadership realized that this is squarely a Section 16 matter of all what the other courts, this court has found in the other 2 matters, then that would have it would have followed. Well, maybe in the yes. Well, my lady, thank you. The legality case is, I mean, honestly, that one, I don't even think there's a need to address your leadership. Your leadership found that the SABC was not exercising a public power. I mean, there's just simply no basis for that. And I'll just refer your leadership to a case, since there's no time. It's called the DA versus the SABC. Okay, same case, except that this time it's not the DA, it's the MK party.
Yes,
but the same kind of thing. Yeah. And this is what Judge Rogers said in that case. Oh, sorry, I'll to give you the citation because it's not in our heads.
Okay, thank you.
Yes, 2017 bracket 1.
Yes.
All SA.
Yes.
530.
Yes.
Bracket WCC.
Yes, thank you.
Yes, and again, fortunately, this also relies on a constitutional court case in chief. So this is what Rogers J said. In my view, therefore, the SABC is a public body. I mean, as if that needed to be stated.
Yes.
So when it acts, is generally exercising a public power. And the argument here, my lady, was that, well, when the SABC was firing someone, it was not exercising a public power. It was just like any other employer. Then he says, yeah, in regard to employees, the SABC's power to engage its staff is in Section 26 of the Broadcasting Act. I've referred to the equivalent here.
Yes, I have the point. I have the judgment.
Fine.
Yeah. I am wrapping up now, I'm afraid,
yes,
Mr.
Yeah. No, okay, let me.
I've given you your 5 minutes is up. Well,
it's not, but it's fine. All right. Those are some.
Yes, thank you. Thank you. Thank you. Mr. Mattal?
Thank you, my lady. For improved bandwidth, if I might just ask my learned friend to perhaps mute his camera. And perhaps to come back on when he replies. My lady,
Yes.
I'm going to try and deviate from what we had prepared to address your ladyship, and I'll give your ladyship the references at the end in terms of the main points. But
yes,
I will. Sorry, my lady friend is okay. Thanks. My lady, it is important perhaps to set certain principles correct in relation to the submissions that were made by learned friends, most of which we submit with respect are incongruent with legal principles. And let's start with the Baloyi judgment, which is where our learned friend started. Your ladyship will recall, and in fact, your ladyship's recollection about what Baloyi was about is indeed correct. I'm just going to ask your ladyship to look at paragraphs 1, 3, 7, 9. If perhaps your ladyship can just note so that I don't detain your ladyship for long.
Yes. 1,
3, 7, 9, and then I'm going to read paragraphs 11 and 12, just to indicate that your ladyship's off-the-cuff recollection of what was involved in Baloyi is indeed correct. Under the heading of jurisdiction, which the court deals with, commencing from paragraph 10, my lady, in paragraph 11, the court says Ms. Baloyi's jurisdictional challenge turns on a question of law. Simply put, Ms. Baloyi asks this court to answer the following question. Does section 1571 or read with section 1572 of the LRA extend the labor court's exclusive jurisdiction over an alleged unlawful termination contract of employment? This raises a constitutional issue because it involves the interpretation of section 1571 of the LRA, read with 1572. The interpretation of the LRA axiomatically raises a constitutional issue. Then 12, the declaratory relief sought calls for the adjudication on whether Ms. Mkhwebane, in her capacity as the public protector, has complied with her constitutional obligations. And the review relief requires this court to determine whether the public protector, who performs an essential constitutional function, has abused her power, and in doing so, the Constitution and the principle of legality. This court's jurisdiction is therefore engaged in relation to the substantive relief sought by Ms. Baloyi. And your ladyship will see in the earlier paragraphs that I've referred your ladyship to, your ladyship will see there is reference to section 181 and section 182, which had been pleaded by Ms. Baloyi in her founding affidavit.
Yes.
So my lady, the important principle is this, that what our learned friends postulate to your ladyship is the proposition that when the parties refer to a matter as a constitutional matter, you are bound. It is indeed incorrect. Your ladyship, if I can ask your ladyship to turn to our heads.
Yes.
Case lines 31-15.
Yes. 31-15.
15.
Yes. Yes.
Commencing from paragraph 37, and the point we make with reference to the well-known Chiro decision, to which we referred your ladyship during argument. And there are many other judgments that follow this decision. Busak and them. There is a well-established principle which is not overturned by the Constitutional Court in Baloyi, which is that a matter does not become a constitutional matter simply because a party has labeled it as such.
Indeed.
And your ladyship would have to engage the properly pleaded case and whether it involves a constitutional case or not. And And the reason why your ladyship engaged with our learned friend at length with that question, it is because that is the prism of Section 172.
Mm.
And just to underscore the point that your ladyship made to our learned friend, MLO does not detract from this position. All that MLO says is you don't need to declare something as unconstitutional.
It doesn't need to involve a declaration of invalidity for
Correct.
you to have the powers that 172. No, I understand
yes.
the principle. That's
yes, my lady. So none of those cases detract from the well-established constitutional law jurisprudence that whether something involves a constitutional matter is a question that your ladyship would have to determine.
But all right, let's move on from that.
Yes.
Mr. Mpofu says, but it does, regardless of what the parties say or don't say. It inherently involves constitutional issues because it says it involves a Section 16 issue. What do you say about that?
My lady, two things. The first thing is your ladyship will recall we devoted a lot of time during the hearing of the matter in showing the deficiency of the pleadings.
Yes.
And we spent a lot of time, my lady, to show, and we also referred your ladyship to the Mkhwebane decision where a similar thing had occurred. The differences being paragraphs 49 in the one judgment, in the one founding affidavit, and paragraph 50 in the one before your ladyship, which is that there is a constitutionally non-specific pleaded case, which is inherently defective.
Yes.
So that doesn't get the applicants off the starting block. With respect, it doesn't, my lady. And perhaps let me go to the second point: the fact that the SABC refers to scheme and our learned friend refers to the answering affidavit of the SABC, and all that the SABC there says is if the relief that the applicant seeks were to be granted, it would breach the SABC's duties in terms of Section 16 of the Constitution. It does not mean that the applicant has made out a proper case that brings its case, or at least its facts, within the ambit of Section 16. So that's a big distinction, lady. So
yes.
In other words, we say in the answering affidavit the relief is incompetent, but if it were to be granted, it would breach the SABC's constitutional duties.
Yes.
And let's use the example, my lady, that just to remind your ladyship. Your ladyship recalls we spent some time on the FXI judgment, which actually undercuts the very point that our learned friend is making. With reference to FXI, your brother Klassen there dealt with the corollary of what we're dealing with here. And your ladyship will recall it was the suppression of information by the SABC, the failure to disclose the Sisulu report, despite the fact that it had been called for, etc., etc. And His Lordship Justice Klassen made two findings, and your ladyship will find that in paragraph 99 of the FXI judgment. I just want to go through the issues very quickly.
Yes.
His Lordship found that there was a breach of the internal policies of the SABC and the sections of the Broadcasting Act which had been pleaded. And your ladyship will recall why that was important. It was because it was also raised not only from the perspective that they had sought the wrong remedy by directly relying on the Constitution, but that there were issues relating to the internal remedies, to which I'll comment. So their point, lady, about directly invoking the Constitution illustrates the lack of prospects of success.
Yes.
And the absence of a compelling reason why another court would come to a different conclusion, or why it is in the interest of justice that another court would want to hear the matter, because the relief and the pleadings infringe the principle of subsidiarity, which your ladyship recalls we dealt with at length, and our learned friends dealt with the argument, and they were afforded an opportunity by Her Ladyship to file supplementary submissions on the question of subsidiarity. So it's an important issue, my lady, because that cuts across quite a number of issues, including the competence of the relief that they sought. My lady, the question of internal remedies is also implicated on the basis that our learned friends say, because it is a constitutional issue, it renders the internal remedies incompetent to be invoked for purposes of granting remedy. And we spent time in showing your ladyship why it is so that on these facts, the SABC, in its letter of response to the applicant's letter of demand, was correct in pointing the applicants to the duty to exhaust internal remedy. Because what this is a complaint that the broadcast was inaccurate. And by extension, then they seek to invoke Section 6 of the Broadcasting Act. But herein lies the difficulty of the applicants in that conceptualization of the case. There is nothing inaccurate in the SABC reporting that the government refers to itself as the GNU, that there is a controversy about the correct usage of that political term, and for the SABC to provide a platform for different political commentators to argue whether it is or it isn't a GNU. All that, my lady, is accurate. What the applicant wants to do, it seeks, or the applicants seek, in plural, they seek to invite this court to enter that political debate and to determine.
That's the point I centrally made. It's
Correct.
not for this court
Correct.
to enter a debate into whether it's wrong or whether it's right. I did say that if I were, this is what I would think it was, but I'm not called upon to do that. A court can't be called upon to do that.
And my lady, that is why we argued that point as a powers matter, not the jurisdiction as with respect the applicants seek to use in a self-serving and in a cynical.
It's just, clearly there was no finding that I didn't have jurisdiction proper. There's a finding that one doesn't have power to make declarations because there's no constitutional issue. Clearly the position is clear. The judgment went on for 11 pages. It didn't deal with any kind of mechanisms of jurisdiction. It dealt with the issues pleaded.
My lady, just to close this point, and your ladyship will recall, we even made the submission that if the SABC had done the contrary, it would still have been in breach. But the argument would have come from the other side, that the SABC is descending into the political arena by taking sides, whether it is or it isn't. And the SABC says, clearly, it is not the arbiter of that question.
But also, what is a government of national unity? There was a reliance on some alleged dictionary definition.
Yes, the Oxford.
Well, it's not the Oxford. It's a political treatise that it's not an Oxford. It's not an
Point.
Oxford
Point 10.
So there isn't a definition of what unity means.
No, my lady, and
that's got to be the starting point. In the same way as there isn't a definition of what true communism means, doesn't mean you can't call yourself the Communist Party.
Your ladyship dealt with the issue, including democratic,
Yes.
or whether the ANC is actually a national Congress. Your ladyship dealt with.
It's the same argument. It comes
Precisely.
down to the use of controversial terms. And Mr. Mpofu seeks to get away from the use of the term controversial. Well, it is controversial, and it's controversial as opposed to accuracy. And that's the point.
But that's the point, and that is why the applicant's invocation of accurate reporting and seeking to rely on the provisions of the Broadcasting Act is with respect skewed, because it seeks to avoid the nature of the animal that we are dealing with for purposes of adjudging whether there has been a breach of accurate reporting or not. Because in context, you've got to say it's a politically controversial term. The SABC refers to the government as it refers, or as it calls itself. It invites commentators to inform the public in accordance with its duties set out in Section 16 that there is no hegemony or there's no agreement regarding whether this is a GNU or not. And that is accurate, and that's compliant with Section 6 of the Broadcasting Act. But
it recognizes the controversy. That's all it needs to do, and that it's done. You made that point.
But my lady, just to conclude, if the applicants are correct, they would have had to seek the relief similar to the one that was sought in FXI, i.e. there's a breach of the provisions of the Broadcasting Act and the SABC's policies. It's not a constitutional issue.
Well, you can't leapfrog in that way, and that's the subsidiarity
that's the point,
which they were given the opportunity to deal with.
And my lady, just for your ladyship's notation, in paragraphs 43 to paragraph 47 of our heads, we deal with the subsidiarity point, read with the principle of constitutional avoidance, which your ladyship is aware of, and we advanced it. We advanced it in the presentation of the case. That
all right, let's get away from subsidiarity.
Yes.
What do you say about the fact that they state that they want the exceptionality applied to them? So they didn't exhaust remedies. They say that they asked that they be given exceptional status in that regard. What do you say about that?
Well, lady, two things again there. When this argument was raised, we dealt with it on the following basis. There's no relief sought in the notice of motion for your ladyship to extend or to exhaust them from the internal remedies or from the duty to comply with internal remedies. And your ladyship will recall, we dealt with the cases such as Denge Tenge, and I even referred your ladyship to the one judgment by your brother, the DJP, that deals with this, with the duty to exhaust internal remedies. And
but Mr. Mpofu argues,
yes,
you must read, he says, the notice of motion together with the affidavits. But the fact is, the relief is not sought, and as I understand, what they say is that they would be entitled to it. But I don't see why. Do they make out a case as to why an exceptional procedure should be allowed to them?
But my lady, let's assume I want to meet it at the level of them having made out a case. Let's move from that premise. Because,
let's move. Yes, indeed.
It doesn't then transpose into that relief being sought in the notice of motion.
No.
That's and that's a deficiency. I mean,
well, that's the
court,
pleading. That's the
yes,
pleading.
Constitutional Court decisions. The one that comes to mind is Shelley Court, SHELLEY versus Betlane, BETLANE. My lady, I can't recall the citation, but Shelley Court and Betlane, it espouses the principle that our learned friend seeks to rely upon, which is that an applicant, even in constitutional matters, is bound by the notice of motion and the founding affidavit. But what that decision does not say is that absent a specific prayer that is being sought, her ladyship can, of her own accord, transpose the allegations in the founding affidavit to the notice of motion. That, with respect, can't be done.
And there was no application to me.
No. This. So my lady, that should dispose of,
Yes.
of that issue. But in any event, your ladyship dealt with the. I see my lady friend comes back on.
Okay.
Oh, sorry. But in any event, your ladyship has dealt with the remedy and its incompetence. It is not only because our learned friend, or sorry, our learned friend's clients failed to exhaust the internal remedies, but your ladyship dealt with the 3 forms of relief. Your ladyship dealt with the 172 relief and why it was incompetent. Firstly, your ladyship dealt with the Paja review. And that should be informed by the debate that took place before your ladyship. And your ladyship will recall why we said there is no administrative action that has been taken. We were relying on the Motau judgment and the 7 elements. And so this judgment is not a judgment in the abstract. It's a judgment that's given in the context of the debate that was had before your ladyship. So that's the determination of the merits on why Paja does not apply. And then the third aspect is that of legality. And your ladyship says there is no exercise of a public power. And it is indeed correct that is so. Because all that happened, my lady, is the applicant said the SABC should refrain from referring to the government or calling it as a GNU. The SABC in Annexure MK8 in the papers responded to that. And why? Well, in advance, at least 2 reasons. Firstly, it says that if we were to accede to that, it would infringe the SABC's the SABC's constitutional duty to comply with Section 16, i.e., represent plurality of views on the subject matter. That's the one. And then secondly, it says, in any event, you are complaining about an editorial issue. Invoke the remedies. So, my lady, well, in the absence of a constitutional issue, there is no reason why the internal remedies ought not to have been followed. So, my lady, whether the decision to say yeah of near is the exercise of a public power it is of no assistance to the applicant, because it takes them nowhere. Even if your ladyship was incorrect in labeling the SABC's response in that letter MK8 as the absence of the exercise of a public power, it still doesn't make out a cause of action. And that's the reason, my lady, why we make the submission in our heads with reference to the Dex Group judgment. The one of the fundamental errors with this application for leave to appeal is that it seeks to impugn your ladyship's reasons and not the order. And that is why, my lady, going down this path will lead us to these semantics, whether Ferreira versus Levine has got a paragraph 16 or it doesn't. You've got to deal with the substance. And my lady, it was surprising, and that is why I immediately picked it up in footnote 43, because your learned friend, because our learned friend said, I don't know whether, my lady, it's part of the stare decisis principle that counsel mentioned, the fact that they were involved in matters. As far as I know, we go to the ratio of the decision and we don't buttress it by whether we were in the matters or not. So to the extent that was invoked as a basis to extend the application of the stare decisis principle, your ladyship, we ask her to ignore that. But the point why, my lady, I even said, can we just not waste time? Because it is clear for all constitutional law practitioners that Ferreira versus Levine has got more than one judgment.
Yes.
And in fact, that very judgment that our learned friend relies upon points that fact. But, my lady, it's not even about it. It is about the nitpicking point, which is the second of the last 2 points that I'm going to deal with, my lady. in our heads, might I ask your leadership to turn to 31-5.
You want me to turn it up?
Yes, my lady, please, because it is an important principle which we think finds application here.
31-5.
31-5.
Yes.
It's an important principle, and we would implore your ladyship to say something about it in the judgment.
Yes.
My lady, we refer to the scattershot approach in the argument that has been taken, and we say so, relying on two judgments that we cite. The well-known decision of Heng, which is in paragraph 4, and the Kutsia judgment in the next paragraph. And my lady, the point that the courts make is, if I can deal with Heng first, the application for leave to appeal had listed 65 grounds on which the Kotako was alleged to have erred and misdirected itself. And if my lady can just skip the rest, she'll read it in the fullness of time. Just go to the underlined portion. In any event, it should have been apparent to the appellants that the learned acting judge could not possibly have intended his words to be taken literally. And we invoke that for purposes of this argument about jurisdiction. It's clear in context what it means. But my lady,
you know what? But it's not even an inaccurate use.
No, it's not.
There are two jurisdictional issues that arise. The one pertains to 172,
yes,
power jurisdiction. The other is the jurisdiction to hear the matter, and that clearly was not in dispute.
We make the point that your ladyship determined the matter on the merits in any event, which shows
Indeed.
that's not the meaning. That's not a proper meaning to ascribe to the term. But my lady, just to conclude the submission, the underlined portions before we close the. On the contrary, the manifestly indiscriminate formulation of the grounds on which the application for leave to appeal was brought brings to mind the observation of a U.S. appeals court judge that when he sees an applicant's brief containing 7 to 10 or more points, a presumption arises that there is no merit to any of them.
Well, I don't know. I would not subscribe to that.
Well, my lady,
one must take to the. Sometimes there are a number of bases. So maybe the U.S. appeals court is less cautious than I would be.
My lady, we just simply illustrate this point, and your ladyship will consider. She might agree with us. She might think there's no basis to.
It's not about agreeing with you. It's not. I don't think that it's a cogent or responsible approach to take, to say, well, there's so many grounds, so all of them. I'm not going to consider any of them to be.
No, my lady.
So no, but I understand the argument.
Yes, my lady. You see, the U.S. appeals court and the two courts in our country, they invoke it merely as a presumption and nothing and no higher, my lady. And we are not saying, therefore say there is no merit. We say that presumption immediately applies because of what we say in paragraph 8 of the heads.
Yes.
My lady, we did the arithmetic there, and your ladyship will see the total that you come to is 48 grounds of leave to appeal. All we say in a misguided attempt to impugn an 11-page judgment. Just that presumption.
It's a very simple judgment. I see that there seems to be some criticism that it was handed down too quickly. I must tell you, it's the first time I've been accused of handing down a judgment too quickly.
My lady, the irony is this. This is the point that we make. The irony is this matter first came as an agent before your sister, Yakub J. She struck it for lack of agency. And my lady, before I proceed, we make the point in the heads, and the leadership will find the judgments that when a court makes a finding about lack of agency, it doesn't deal with the merits.
No, of course not.
So the remarks by Yaqub J are not binding to you, my lady, beyond having made a finding.
It wasn't an issue. It wasn't an issue dealt with in any way.
Yes, but in any event, my lady, you recall the debate between a dismissal and a striking off, and how far does one go? That it goes there. So what she said could not sound you in any way, manner, or form. But my lady, they have launched this application for leave to appeal on an urgent basis. And your ladyship saw, they said urgent application for leave to appeal. And when your ladyship renders a judgment urgently in that context, then it is a basis to find or to found a ground for leave to appeal, my lady. And these are some of the examples why we show that the presumption by the US Appeals Court, which is followed by the two other divisions, my lady, is well made, insofar as we make the submission that this typically falls into those cases where the presumption must be made. But of course, it doesn't absolve your ladyship of the need to deal with the arguments. And that is why we're not simply saying make that presumption and therefore say that. So
no, right.
We engage with why the merits are bad, and why we submit no proper case has been made out. Lastly, my lady, the question of costs. We deal with the question of costs from 3518.
They correct me, but I have to cast my memory back. But I don't believe that they raised BioWatch.
I think they did, my lady.
Did they?
They did, and in fact, they had also done so before Her Ladyship Justice Yaqub. I must just be fair to them. And your sister didn't make a cost order because she took a particular against the SABC's delay in complying with the terms set out in the notice of motion. But they did, my lady, invoke BioWatch. But we had indicated in our
but look, I dealt whether they did or whether they didn't.
No, you dealt.
I saw fit to deal with it, and I dealt with it.
Yes, but my lady, in any event, we made arguments before your ladyship why BioWatch finds no application on the facts. And if I can just give your ladyship the additional references in our heads, your ladyship can look at it in the course of writing her judgment. We deal with the costs from 31-18. And if I can just ask her ladyship to look at paragraphs 50 to 53. And we wish to emphasize the decision of HOTS.
Yes.
The HOTS decision deals with and basically the question of jurisdiction, the question of a discretion.
Yes.
And that the cost order is the exercise of a discretion, and an appeal court, the fact that an appeal court may have a different view. And this is paragraph 28 of HOTS, which we quote in paragraph 45. So
it's one of those discretions, one of that type of discretion.
Correct.
The appeal court would have to find that I was absolutely incorrect, and there was no basis at all for the finding.
It was egregious, absolutely. And those are the points we make with reference to the Lawyers for Human Rights decision in paragraph 53. Malady, unless there's anything specific.
No.
Understanding.
No, it's always an easier job to be a respondent in an application for leave to appeal. And that is why I have given Mr. Mpofu more time, and I've attempted to convey to him my considerations. But I've read the heads, I've read his heads, I've read your heads. And I have nothing further to engage you with.
Yes. I'll save the time. I didn't use the whole 30 minutes. if I have another matter before your ladyship, I'll call on your ladyship to please give me the balance of that time.
You want it in the back, okay?
Thank you. Thank you, lady. Those are submissions.
Thank you. Yes.
Thank you.
Mr. Mpofu, I hope the same doesn't apply in reverse, that when you have another matter in front of me, you should get no credit.
Well, all I'll ask for is just an opportunity to speak, my lady.
Indeed.
Yes, thank you. So, my lady, let's just try to do this in point form. Maybe it will help. Yeah.
Yes.
So the first question, my lady, is, does the SABC, as an organ of state and a public service broadcaster, have a constitutional duty to impart accurate information or not?
Yes.
If it does, as it obviously does, by reference to Section 3(5) of the Broadcasting Act,
Yes.
and by reference to its own policies, by references to anything to do with
No, indeed. I accept that.
If it does have that duty at all, then somebody who says that constitutional duty, the one we've just spoken about, has been violated in my case, rightly or wrongly, is that person raising a constitutional issue?
Why is it inaccurate to give somebody a name? You see, it comes down to accuracy. Your argument always comes down to accuracy. And this is not this is not an objective. This is not something where you can say it's objectively accurate or not accurate. And the same as the Democratic Alliance. Some people may say you can't call yourself democratic. You're not, because of X, Y, and Z reason.
Lady,
you can't call yourself an alliance. You're not an alliance. So you're going to keep saying to me accurate, and I'm going to keep saying to you controversial, and that's where we're going to end up. Why is it not accurate to call an entity or an organization or a conglomeration by a name that they have given themselves?
Yes, my lady, your ladyship, really, this is so frustrating. Your ladyship must not deal with the merits of the case.
Yes.
Please, I'm asking a simpler question. Let's assume it's accurate. Okay, maybe that will help us. Assume it's accurate. Okay? Does that question, whether it's accurate or inaccurate, deal with the constitutional obligation of the SABC to impart accurate information or not? Let's say the answer is that it's accurate, because that seems to be, that's an off-ramp that I don't want to go to, but let's go into it by that. Let's say in the end, you find that it's accurate. It's government of national unity. The only issue I'm raising with you is whether that issue implicates the constitutional obligations of the SABC to give accurate information or not. That's all. Yeah. So the answer to that question is obviously yes. The answer to the question whether it is accurate or not is irrelevant for the purposes of my argument now. It is whether this matter implicates that right, that constitutional duty.
Yes, I have your point in the first instance. Please, will you confine yourself to reply?
Yes, but well, your ladyship is the one who raised the issues of controversy. I'm not there. I don't even want to deal with those things.
I know.
Yeah, no one has pleaded controversy.
Yeah. No, I know you don't.
It's only pleaded accuracy. Yeah.
Yes.
So if we wanted to plead controversy, we would have pleaded it.
Yeah.
Yeah, I've never heard of a duty of the SABC not to deal with controversial matters.
Yes.
That would
Indeed.
be upset. Yeah. Now, so if we accept then that the SABC has such an obligation, and that these applicants are invoking that, then you don't have to believe us. Go to paragraph 31 of the answering affidavit.
Yes.
You'll find that at 25-14.
Yes.
This is not us. This is the SABC. It says,
Yes.
the relief the applicants seek implicates Section 16(1) of the Constitution, which enshrines the right to freedom of expression, which includes the freedom of the press and other media, as well as the freedom to receive or impart information or ideas. I couldn't put it more beautifully than that. So that is what this case is about, according to everyone in the world, irrespective of its outcome. Okay, so let's put that aside.
Yes.
Yeah. So to the extent that this court said this matter does not implicate a constitutional right, that is a conclusion that another court would find differently on.
Yes.
So
and that's the question. That's what we started off with.
Yes.
That is
so
the
next,
question. That's
yes,
the start.
the only question.
The only question.
Yeah,
I agree. Now we agree.
Yeah. So if these parties are both correct, and we accept that the section is correct and the Constitution is correct, then they forget the outcome for now, but controversy and whatever. Just whether this case involves this or doesn't involve this. Okay.
Yes.
That's number one. Number two, my lady, and your reference will be paragraph 31 of the answering affidavit, and 32 for that matter.
Yes.
But I won't read it because of time. Yeah. Okay. Now, the question of yes. The questions of subsidiarity and all that jazz do not come to it, my lady, because the issue that we have raised is the issue of the case of the Islamic unity. That's the complete answer to that. I want, again, to save time, yes. I'm not going to quote it.
Yes.
Then, your ladyship, this is one of the issues. My learned friend did not address, in fact, I think half-heartedly considered the point about that this is not a decision of the CEO, as your ladyship incorrectly held.
Yes.
And what you want to say about that, my lady, is that not only was it wrong what your ladyship said at paragraph 41 about
yes.
that, but your ladyship says, and I'm quoting now, this was conveyed in the letter containing the refusal in issue. The fact that the CEO does not have the power. Well, that's not true. It's not. That letter, you can look at it, my lady, it doesn't contain any such thing whatsoever.
Yes.
And it can't because the writer of the letter clearly understood. And you can see, I don't want to go to the letter directly, that she's speaking on behalf of the SABC. So yes. I don't know where that came from, because that's definitely not the case. Now, then we have this unfortunate debate about which Ferreira versus Levine and so on, irrespective of the fact that I have explained thoroughly that I'm assuming that that's a typo. It says, though, in my head, right?
Yes.
And it says, yes.
Fair enough. Fair enough.
Yes, and it says, yeah, honestly. So the point we're making there is that you can get the correct Ferreira judgment, which is the 1996 one, at paragraph 57, does not make the issue the principle that your ladyship says it does. That's the point. It's not about typos.
Well,
it's about, yes. You can read it in your own time. Paragraph 57 is about what they call the independent protection of specific freedom rights, should be more properly designated as residual freedom rights. In other words, when we say you have a right to equality and freedom, there are residual rights which might not be spelled.
Well, that's what I was referencing in the body of the judgment.
No, it is not. It is not. What you are saying, my lady, is this.
Well, what I was saying is safe.
No, it's not. This is what you were saying at paragraph at paragraph 14.
Yes.
The subjective positions in which the parties find themselves has no bearing on the determination. The inquiry conduct is either inconsistent or consistent with the Constitution, which, by the way, that means that's a constitutional issue. That's a contradiction on its own, because if conduct is either consistent or inconsistent, that's the very question that's asked by 172.
Yes, yes.
But by the way, yeah. So you said a court will not restrict its inquiry to the position of one of the parties to a dispute in order to determine the validity of the conduct that is condemned to be inconsistent with the Constitution. And then you reference Ferreira. Ferreira does not say any such thing. The paragraph 57. That's the point we're making. And it can't. Ferreira could not say such thing because that's not the law. The law is that is explained in the EFF case at paragraph, I think it's 103. So let's not get bogged down about typographical errors. It's the principle that we're talking about. Then, my lady, just honestly, I want to know, my learned friend again does not address this. In fact, he concedes it to his credit. But I don't know if the court actually is alive to this. That the legality review was rejected by this court on one ground and one ground only, that the SABC was not exercising public power. Wrong, plain wrong. And the basis for that is in Chirwa in the Constitutional Court and the DA versus SABC case that I cited to your ladyship. So it's not even debatable as to whether when the SABC makes a decision to respond one way or the other, or refrain from doing something or whatever, is exercising a public power. It clearly is. What other power? It can be exercising a private power. It is purely, so the legality review on its own, forget everything I've said today. The legality review was rejected on the patently incorrect basis. And surely another court will agree with Chirwa, will agree with DA versus SABC, that the SABC is exercising a public power. That's just on that basis alone, my lady. The application for leave to appeal ought to succeed, because your ladyship knows as much as I do that the alternative claim for a review, let's assume all these things about intermediaries and what have you were correct, but the alternative claim on legality does not depend on internal remedies. It's a claim in its own, and it was wrongly rejected. So just on that basis alone, the application for leave to appeal should be granted. Then the last point is this thing about notice of motion. We specifically say in the founding affidavit that the basis upon which we're asking for that relief, which is in the notice of motion, that you should review this decision, is to the extent that, and this is on the alternative, we say in the alternative, if they say that we did not exercise internal remedies, it was just a preemptive submission. These, and in page 81, 82, I think up to 80, 81, 82, we give the reasons why that exemption should be granted. In the answering affidavit, there is no refutation of those grounds for the exemption. And then you get given a technical argument here that, well, despite that matter being fully pleaded, despite it being common cause because it was not disputed, because in the notice of motion, there's no specific prayer, then you must ignore all that. I mean, in which country does that happen? The Constitutional Court has said so many times that if relief, that's why you have that thing called just and equitable relief. Constitutional Court has said that if relief is pleaded, it's competent on the papers, and it is canvassed in the affidavits. I just forget the name of the case. But this is a tried principle. Madlanga J said this, yeah. In that event, the court is fully entitled under its just and equitable, wide just and equitable jurisdiction. Surely, I mean, which court is going to say, well, you did not have, you've asked for just and equitable relief, you've pleaded this thing fully, but you did not specifically use the words A, B, C, D, or whatever.
Yes, look, Mr. Mpofu, I'm going to stop you. I have the arguments. This might be one of the longest applications for leave to appeal that I've ever entertained, but I have your arguments, I have your heads. So I'm going to, I did say I would keep you strictly to time. I haven't, because I've been more charitable than I should have been.
15 minutes. I thought I had 15 minutes in reply, but that's fine. That's fine.
And how long have you had?
Well, I did not time myself, but I know that it was after my learned friend around 10 past or so. But it's fine. If your ladyship is inclined not to listen to any more submissions here.
Yes. Yes.
Sorry, Malini, just one thing. I made it clear that we're not repeating our argument in the application for leave to appeal. But it's incorrect for my learned friend to say we are conceding this, because he'll recall in the main argument at the hearing, we said there's only one reference to legality, and that's in paragraph 13. There are no facts whatsoever. He can't amplify it in
indeed.
Argument.
You know, this really, counsel, both of you.
Thanks.
This is an application for leave to appeal.
Thanks.
It's not a rehashing.
Correct.
And I have your submissions. I have them in writing. And you can content yourself that I will consider them very carefully.
Thank you,
my lady.
Okay.
Yes.
Yes, my lady, sorry, I have a right to reply to that. The only issue I'm making, my lady, is not, I don't care whether my learned friend has considered or not considered the point. The point is made in Chirwa that the public, the SABC, in DA and in Chirwa, it's to do with Transnet, that those bodies exercise a public power.
Yes,
and so
I accept that, and that wasn't, if you look at the judgment correctly, I accept that they exercise a public power. It's a question of whether they exercise a public power in using the term, and that's the distinction.
No, well,
but they exercise a public power, and I accept that. So,
okay,
so we're added.
In the judgment, you reject it, so that's fine. That's yeah. If you accept it today, then that counts for application for leave to appeal to succeed. Thank you, Malin.
Yes, thank you. I am going to reserve judgment, and you will be notified in the usual way of the judgment being handed down electronically.
As God please.
Thank you, my lady.
The court will adjourn.
Yeah.
you.